Count 1, F5, possession of cocaine, and the forfeiture specification for the drugs and paraphernalia and instruments attached to count 1. Also, count 2, felony of the 5th degree, possession of fentanyl-related compound. Upon condition of those guilty pleas being forthcoming after findings of guilt at the time of sentencing, the state will move to dismiss count 3. The state will review the pre-sentence report prior to making its sentencing recommendation. It's my understanding the defendant wishes to request community control as a sentence.
Thank you. Ms. Tomasic, does that sound accurate?
Yes, Your Honor, that is all accurate.
Ms. Katkowski, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here this morning?
Yes.
You need to speak up.
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered pleas of not guilty to counts 1 and 2 and plead guilty to those 2 charges. Count 3 would then get dismissed. We would defer sentencing to get some reports completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations. Each side is free to recommend to the court whatever sentence they believe is the fair and right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yeah.
Well, before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with in pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all these issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right? You need to respond verbally.
Yes, Your Honor.
All right, let's get started then. How old are you?
33.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No.
What about in the last 48 hours?
No.
Not even prescribed medication, nothing?
Blood pressure medicine?
Is that it, just blood pressure medication? Okay. Took that this morning or last night?
This morning.
Now, you would have previously received a copy of the indictment in this case. You probably got it back in the spring sometime, beginning of April. It's a document that sets forth the specific charges you're accused of committing. Do you remember getting that document?
No.
Well, you would have received it before the arraignment. In that document, you're charged with 3 counts. You're pleading guilty to 2 of those counts. Count 1 was alleged here, and what you're admitting to is on or about April 13th, 2021, in Mentor Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with in pleading guilty to in count 1?
Yes.
Any questions about it for me?
No.
Now, the charge also carries with it what we call forfeiture specification, which alleges that during the commission of the offense you possessed or had some interest in property that was considered to be contraband or an instrumentality. Contraband is property that's illegal, just by the nature of the property itself, like drugs. An instrumentality is some type of property that there may not be anything illegal about it in and of itself, but it's being used in an illegal manner or to facilitate a crime. You can't possess it for that purpose. And here it's alleged that all the drugs, the paraphernalia, and the instruments were confiscated as evidence as contraband or instrumentalities. And the whole point of this is that you just forfeit any ownership interest you have in that property. It doesn't increase any possible penalty or sentence. You just lose your right to that property. Do you understand that? You're not going to get the drugs back or the pipes back or whatever other evidence they found that gets forfeited to the state. Do you understand that?
Yeah.
That's all that's for. Count 2 alleges on or about April 13th, 2021 in Mentor Lake County, Ohio, that you did knowingly obtain, possess, or use a fentanyl-related compound or some mixture, preparation, or substance containing a fentanyl-related compound. The amount did not equal or exceed 1 gram, which makes the offense possession of a fentanyl-related compound a felony of the 5th degree. Do you understand what you're charged with in pleading guilty to in count 2?
Yes.
Any questions for me?
No.
Now, there is a third count, possession of drugs that's being dismissed pursuant to the agreement. Is that your understanding?
Yes.
Any questions about that third count?
No.
Well, then before I can accept your guilty plea to the two counts I just read to you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have a right to a trial. Now, a trial could be to me as a judge, where I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens from this county who would listen to all the evidence presented. Those 12 citizens would consider and weigh all that evidence, and then they would make the ultimate decision. And that ultimate decision reached by those 12 citizens, the jury, would have to be unanimous, which means all 12 of them would have to agree together, one way or the other, whether you were guilty or not guilty of the charges. Do you understand that?
Yes.
Do you understand by pleading guilty, you are giving up your right to have a trial?
Yeah, I think I'd rather go to trial.
Go to trial? All right, we'll go to trial. When's our trial set?
October 7th, Your Honor.
Well, we'll figure that out. But this is we're not gonna. If you come back for a plea, you're gonna be pleading the whole indictment. You understand that? So if you're gonna plea and to accept the state's offer, we're gonna do it now. You're not gonna get a chance to come back here and say, "Oh, I've changed my mind again, and now I want to accept the state's offer." And that's fine. We could have a trial. I have no issue with that whatsoever. But we're not going to go back and forth with it's a plea, it's a trial, it's a plea, it's a trial, because we've done that a couple times already. You understand that?
Your Honor, could I have 1 minute just to talk to Ms. Kutkowski?
No. She makes sure she took. You want to have a trial? Okay, we'll set up for trial.
All rise.
We're here this morning in State of Ohio versus Joseph Melenda, case number 25 CR 362. Your Honor, the matter is set for a change of plea hearing here today. Mr. Melenda is present. He is represented by counsel Mr. Mark Zuccarelli. Your Honor, it's the state's understanding that Mr. Melenda at this point is desirous of accepting a plea agreement that has, or a plea offer, I should say, that has been extended to him in this case. And if the court would like, at this time, I can lay out the terms of that offer.
Please.
It's the state's understanding that Mr. Melenda would enter a guilty plea to counts 2, 4, 6, 8, 10, 12, and 14 of the indictment. We would ask that count 14 be amended to reflect a date range of December 1st, 2023 through March 31st, 2024. That simply reflects the extent or the duration of the conduct in this case, and it takes into account the counts that are being dismissed. Those are all felonies of the 4th degree gross sexual imposition charges in violation of Revised Code 290705A5. It's at the appropriate time, Your Honor, the state would ask that the balance of the indictment be dismissed. With respect to sentencing, the state has indicated it would cap any prison recommendation in this case at 9 years. I believe that's 108 months, if I'm doing the math correctly. And prior to sentencing, the state would ask that a pre-sentence report and a psychological evaluation be completed. Thank you. Then the defendant is free to ask for whatever he would like.
Thank you. Mr. Zuccarelli, does that sound accurate?
Your Honor, that is an accurate recitation of what the agreement is as to the plea.
Thank you. Mr. Melenda, were you able to hear what the prosecutor and your attorney just had to say regarding what they believe your intentions are here this morning?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered pleas of not guilty and plead guilty to 7 counts of this indictment. I'll go over those with you to make sure you understand them. The other remaining counts would get dismissed. We would defer sentencing to a future day to get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding what sentence should be imposed. The state has agreed that they will cap any prison recommendation at an overall total of 9 years, but you're not obligated to agree to that. You can ask for whatever you think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to speak with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Let's get started then. How old are you, sir?
I'm 20, sir.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, prior to coming into court here this morning, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about within the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
No, Your Honor.
Now, you should have received a copy of this indictment. It looks like you probably got it around the very end of April, maybe beginning of May. That's the document that sets forth the charges you're accused of committing. Do you remember getting that?
Yes, Your Honor.
And at some point, did you have the chance to look that over?
Yes, Your Honor.
In that indictment, you are charged with 22 counts. You're pleading guilty to, I believe, 7 of them. 7 counts. I'm going to go over those 7 counts with you. They're all identical, right, except for the time period, I'm assuming? Or no, the same time period, just different instances in that time period?
Right, the gross sexual
Except for the
positions
last
are
count.
charged alternatively, so those would merge into each other.
Say that one more time?
The gross sexual impositions were charged alternatively under A1 and A5. So those 20 counts are really functionally 10.
But he's not pleading he's pleading he's pleading to all of A5.
5. Right.
So those
Yes.
are all separate counts.
Yes. Right.
I
And I
guess my
should
point
say,
is that they all occurred, they're different time periods for each of those counts?
right, so it's
Okay,
the state's
gotcha.
position that they do not
Right,
merge. They
gotcha.
all cover different time
Gotcha.
ranges.
Gotcha. So in count 2, what's alleged here, and what you're admitting to, Mr. Melenda, is on or between June 15, 2023 and June 30th of 2023 in Mentor Lake County, Ohio, that you didn't have sexual contact with a person with the initials CEM who is not your spouse, or that you caused CEM, who is not your spouse, to have sexual contact with you, and the ability of this other individual to resist or consent was substantially impaired because of a mental or physical condition or because of advanced age, and that you knew or had reasonable cause to believe that the ability to resist or consent of the other person, CEM, was substantially impaired because of mental or physical condition. I'm assuming that's the reason why it's not advanced age, correct?
Correct.
Because of this person's mental or physical condition. That conduct constitutes the offense of gross sexual imposition. It's a felony of the 4th degree. Do you understand what you're charged with in pleading guilty to in count 2?
Yes, sir. Yes, Your Honor.
Any questions for me?
No, Your Honor.
Now, count 4 alleges the same charge, only that it's alleged to have occurred between July 1st, 2023 and July 31st of 2023. Any questions about that charge?
No, Your Honor.
Count 6 alleges the same offense, and specifically, the difference, however, is that the conduct in this offense allegedly occurred between August 1st, 2023 and August 31st of 2023. Any questions about this charge or what you're going to be admitting to?
No, Your Honor.
In count 8, charges the same offense. The difference is that the alleged conduct in this count occurred between September 1st, 2023 and September 30th of 2023. Do you understand what you're charged with in pleading guilty to in count 8?
Yes, sir. Yes,
Any
Your Honor.
questions about this charge?
No, Your Honor.
Count 10 alleges the same offense. The alleged dates, however, in this offense occurred between October 1st, 2023 and October 31st, 2023. Do you understand what you're charged with in pleading guilty to in regards to count 10?
Yes, Your Honor.
Any questions about this charge?
No, Your Honor.
In count 12, it alleges the same offense, only that the alleged dates here are between November 1st, 2023 and November 30th of 2023. Do you understand what you're charged with in pleading guilty to in count 12?
Yes, Your Honor.
Lastly, in count 14, what's alleged is the same offense, only that the dates occurred between December 1st, 2023 and, as amended, March 31st of 2024. So this count has an expanded time frame, which includes a period of 4 months. The allegations are the same. Do you understand what you're charged with in pleading guilty to in regards to amended count 14?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Do you understand the nature of the 7 charges you're pleading guilty to?
Yes, Your Honor.
Now, there are about, what may think, 15 other charges in this indictment. Those are being dismissed pursuant to the agreement. Is that your understanding?
Yes, Your Honor.
Do you have any questions about those other charges?
No, Your Honor.
Well, now, before I can accept your plea to the charges I just reviewed with you, I need to make sure you understand all the rights you're giving up by pleading guilty. And first and foremost, you have the right to a trial. And a trial could be to me as a judge, or I listen to all the evidence and I make that ultimate decision, whether you're guilty or not guilty of each separate charge. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be a unanimous decision, which means all 12 of them would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a jury trial?
Yes, Your Honor.
Now, if we did have a trial, you'd have the right to have an attorney represent you at the trial. If you could not afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, Your Honor.
Now, at a trial, prosecutors here would be representing the state of Ohio, and they would have what we refer to as the burden of proof. With them having the burden of proof, what that actually means then, it is their job, or they bear the responsibility or the obligation to prove you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, in regards to this burden of proof, since this is a criminal case that we're dealing with and it's criminal charges, the burden of proof is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges I just read to you beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to try to do that, if we were going to have a trial in this case, the prosecutor would bring witnesses into the courtroom to testify for the state, and they'd be answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions, and we call that cross-examination. He could ask them anything he wanted to, within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court and testify for you by answering your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. That order is called a subpoena. What a subpoena would actually do is it would force or make someone come to court to testify for you by answering your lawyer's questions if that person wasn't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial, excuse me, I'm sorry, you could choose to testify on your own behalf if you wanted to, but you have a constitutional right not to testify if you don't want to. That's a decision, that's a choice that you and you alone would have to make. Do you understand that?
Yes, Your Honor.
And since that's solely your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutors here are not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
You further understand that if you went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, the court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if I accept your guilty plea, as well as any other issues that you could have raised or brought to my attention up to this date. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
You understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? So you're going to be admitting to the facts being alleged by the prosecutor regarding these 7 counts. We're not going to argue you didn't do this or someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by the court, and you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to 7 felonies of the 4th degree. Each of these are punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, Your Honor.
Now, since there are 7 separate offenses that occurred here, all different time frames, so they're separate events, if I impose a prison sentence, I would impose it on each count, and as the judge, then I have the discretion to run those prison terms either concurrent or consecutive. So concurrent means you'd serve those counts that are served or concurrent together at the same time. Consecutive means one after the other. And they all don't have to be all concurrent or all consecutive. Some can be concurrent, some can be consecutive. But do you understand the difference there?
Yes, Your Honor.
I'm required to make sure you understand the maximum sentence you face. So in this case, if I imposed 18 months on each count, ran them all consecutive, you're looking at a maximum possible prison term of 10 and a half years or 126 months in prison. Do you understand that?
Yes, Your Honor.
Now, are you currently on probation or parole, post-release control to any other courts or agencies?
No, Your Honor.
Do you have any other charges pending against you anywhere?
No, Your Honor.
Now, in this particular case, with these charges, if a prison term is imposed upon your release from prison, you would be placed on what's called post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you served and completed whatever the prison sentence was imposed. And in this case, it's mandatory for 5 years. Do you understand that?
Yes, Your Honor.
And if you find yourself on post-release control and you're violating any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison term I've just mentioned, there are other sanctions that could be ordered. One second, please. Okay. There are the other sentences that can be ordered. And you can be fined. Each count carries with it a possible fine up to $5,000. So with the 7 counts, it's a possible maximum fine of $35,000. You understand that?
Yes, Your Honor.
You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
Also, since the offenses that you are pleading guilty to are what are considered to be sexually oriented offenses, at the time of sentencing, you will be classified as a Tier 1 sex offender, which will require you, upon completion or release from any incarceration that you serve as a result of this offense, to register your place of residence, work if it's applicable, and or education or school if that's applicable, with the sheriff of the county in which any of those places are located. So if it's the same county, you only got to do it once, but if you work in one county, live in another, you have to do it in both counties. You'll have to do that once a year for 15 years after you're released. Do you understand that?
Yes, Your Honor.
You're also not permitted to live within 1,000 feet of a school during that period of time. Do you understand that?
Yes, Your Honor.
And also, if you fail to comply with any of these registration requirements, and I'm going to go over those in more detail with you at the time of sentencing, that's when I'm required to do that. But if you fail to comply with any of those, you could be prosecuted separately as a separate felony charge for failing to comply with your sexual offender registration requirements. Do you understand that?
Yes, Your Honor.
All right. Now, a few moments ago, I explained the possible prison sentence. In doing so, I used the word possible. Prison is not mandatory with any of these charges I just went over with you. With each of these charges, you are eligible for probation, or what is called community control sanctions. Do you understand that?
Yes, Your Honor.
Now, do you understand that just because you're eligible doesn't mean you'll automatically be put on community control sanctions? It means it'll be considered by the court if that's what you're asking for. I'm going to look at all the information presented, then I'm going to make the decision I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are placed on community control sanctions, it could be for a period of up to 5 years, and as the judge, I would have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. Do you understand that?
Yes, Your Honor.
Further, if you're on probation or community control at any point and never violate any of the conditions of your community control, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, including an order that you serve local jail time, or I could terminate or end your probation at that point and send you to prison then. And if I did it at that point, it could be for the period of time that I mentioned earlier, ultimately up to 10 and a half years in prison. And that could be consecutive to any other sentence you may be serving for some other case that may occur after this, or that you're being sentenced to at that time for some new case if that were to occur. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing in about a month or so, you will have the right on that day to say anything you want, anything you'd like me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to the court. You both can present whatever you want the court to consider. If there's other items you'd like me to review, if there's letters you want me to consider, I can do those. I need those before the morning of sentencing, though. But you can do any of that. Prosecutor also has a right to recommend a sentence to the court on behalf of the state of Ohio. Do you understand that?
Yes, Your Honor.
Now, do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along and follow that if I don't think that's the right thing to do. Do you understand that?
Yes, Your Honor.
All right. Will there be any questions at all about the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yes, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your attorney and have him review the reports with you, discuss whatever issues there may be, if any, and answer whatever questions you may have?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your lawyer?
Yes, Your Honor.
Has he or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering your guilty plea freely and voluntarily?
Yes, Your Honor.
All right, then, Mr. Melendez, any questions for me at this point regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to speak with Mr. Ziccarelli before we go forward with your actual plea of guilty?
I'm okay.
All right, then what's going to happen at this point, the prosecutor here, she's going to advise the court as to what the evidence would be in a summary, as to what the evidence would be if we had a trial. I need you to listen to her because I got some questions for you about that, all right?
Okay.
Ms. Blake, for the state.
Thank you, Your Honor. Had this matter proceeded to trial, the state of Ohio would have proven the following facts with respect to the allegations in this case. In June of 2023, the Melendez family moved to Mentor-on-the-Lake, Lake County, Ohio. The Melendez family, consisting of mom, Julie, father, Mark, brother and co-defendant, Luke, the defendant himself, Joseph, and the victim in this case, CEM. The victim in this case, Your Honor, CEM, was 13 to 14 years of age during the relevant time period. She is the defendant's minor sister. Specifically with respect to the impairment in this case, the victim does have cerebral palsy. It is a condition that impacts her muscle control and movement, and at times, to some extent, her cognitive ability. It is a condition that was known to the defendant in this case, as CEM has had multiple surgeries and extensive therapy throughout her lifetime. As the victim described to me, Your Honor, sometimes her brain will want her to do something, but her muscle impairment or muscle function doesn't allow her to do that. She does wear a leg brace and has other forms of assistance, and as I indicated, she's gone through years of therapy. The state would have proven beyond a reasonable doubt that that condition substantially impaired the victim's ability to resist or consent to the unwanted sexual contact in this case. During the relevant 10 months, Your Honor, in Mentor-on-the-Lake, at least once a month, for every month, the defendant would enter the victim's bedroom at night when she was either in bed, asleep, readying for sleep, sometimes had already fallen asleep. If she had already fallen asleep, she'd be awoken by her brother's presence, whether it was her or whether it was the defendant or his co-defendant that entered the room. And then the defendant would proceed to engage in sexual contact with the minor victim in this case in her bed, that included touching and squeezing her breasts, thighs, and vaginal area. The victim had previously disclosed similar conduct to her parents when the family was living out of state, approximately 4 years prior to this coming to light. At that time, she had made it clear, and throughout, she had made it clear to the defendant that this was unwanted sexual contact. The victim in this case, in the relevant time period here, disclosed this sexual contact during her counseling intake appointment, actually at Crossroads on April 2nd, 2024. The defendant then was interviewed by the Lake County Department of Job and Family Services as well as the Mentor on the Lake Police Department. He did admit to the sexual contact. He did admit that it was done for sexual gratification as a way to release sexual tension. And just for the record, Your Honor, although he was a juvenile in the sexual conduct and or contact that occurred out of state, he was 18 years of age, the defendant was 18 years of age or older during the relevant time period here in this indictment. That is what the state would have proven had this matter proceeded to trial, Your Honor.
The incidents you're talking about during the evening when this happened, was he by himself or was he with his brother doing it at the same time? Or
It does not appear that the co-defendants engaged in this behavior together.
so they each did it on their own?
Yes, yes.
Mr. Melenda, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show in this case if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, Your Honor.
Very well, then, regarding counts 2, 4, 6, 8, 10, 12, and amended 14, each charging with gross sexual imposition, each felonies of the 4th degree, what is your plea to each of those 7 counts?
Guilty, Your Honor.
I'm sorry?
Guilty, Your Honor.
All right, I have in my possession here at this time a 4-page document called the Written Plea of Guilty and Judgment Entry, which sets forth everything we've just discussed. The rights you're giving up, the penalties you face, what you're pleading guilty to. Before I can accept your plea, I need to make sure you understand what's in this document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to review and go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Ziccarelli, is that accurate? Did you read this over with Mr. Melenda, review it with him, answer his questions?
Your Honor, we went over it completely. I answered whatever questions he had. Yes, Your Honor.
Did he indicate an understanding of the document to you when you did go over it with him?
Yes, he did.
Is that correct, Mr. Melenda?
Yes, Your Honor.
So you understand the document?
Yes, Your Honor.
It also appears you signed it. Did you in fact sign it?
Yes, Your Honor.
And Mr. Ziccarelli, did you witness that?
Your Honor, I witnessed his signature. I signed it and provided it to the prosecutor.
And Ms. Blake, you witnessed that as well then?
Yes, Your Honor.
Very well then, at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of all those rights. Court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of counts 2, 4, 6, 8, 10, 12, and amended count 14, each felonies of the 4th degree, each in violation of Revised Code section 2907.05A5. Now, the remaining counts of this indictment will get dismissed at sentencing. I'm going to defer sentencing, however. I'm going to order a pre-sentence report and investigation, a psychological evaluation, and a victim impact statement. Bond will be continued at $500,000 cash surety with an order that the defendant had no contact with the victim or any minors. All right, then that covers everything. Ms. Blake, Ms. Gold, anything else on behalf of the state?
No, Your Honor.
Mr. Ziccarelli,
Nothing further on behalf of the defendant, Your Honor.
thank you.
All rise.
Your Honor, if it please the court, we are before the court this morning in the matter of the State of Ohio versus Tremont Crawford, case number 25 CR 1131. The defendant is present in the courtroom with his attorney, Mr. James Matthews. We're here for purposes of a pretrial, Your Honor.
Thank you. Can you give me a brief summary, very brief, of what the case is about, the allegations?
Yes, Your Honor. This Mentor police were dispatched to the Classic Auto Group campus in the city of Mentor because the security guards saw 2 cars and a group of 6 males, or 6 people get out of the cars and trying doors. One of the Mentor police officers who responded about a block and a half on the way from there found the defendant to be in a car that was not his. He had no permission to be in it, driving away from the area. And he had a ski mask on. That's count 2, criminal tool.
Okay.
So he didn't have it over his head all the way. But
Thank you.
Sure.
So this is your case, or are you doing this for Ms. Bell?
This is going to be my case now, Your
Okay.
Honor.
Thank you. Well, let me stick with you. I'm not done yet. Is there an offer the state's going to make at this time?
Yes, Your Honor. The state has extended an offer on September 10th. It relayed an offer to Mr. Matthews in writing where the defendant would plead guilty to count 1, the F4 grand theft motor vehicle. The state would dismiss count 2, the F5 possession of criminal tools. The defendant would agree to voluntarily forfeit all items seized. The state would review the pre-sentence report prior to making its sentencing recommendation. There is no restitution owed per the victim. The defendant, I know, would be requesting community control sanctions. The state reserves the right to revoke this offer at any time prior to acceptance being communicated directly to me, and would reserve the right to modify or rescind the agreement if the defendant violates a bond condition or if he's arrested for or charged with an offense while this matter is pending and prior to sentencing.
Has the state at this point agreed to community control or not?
No.
Okay, but
No.
he's free to ask for it.
Yes,
Gotcha.
Your Honor.
Okay.
The defendant is 18 years old. Don't know what his record is otherwise. No adult record.
Thank you. Mr. Matthews, anything you'd like to add at this point?
Not really, Your Honor. We are in receipt of the offer. Mr. Crawford and I will be discussing it. I will say that I'm not aware of any suppression issues or anything of that nature.
You've received the discovery as well?
I have.
Okay. All right, Mr. Crawford, so you heard what the offer was, and you're a lawyer, and you will speak about that. We don't have to talk about that. But your state has extended an offer, and you'll have to determine whether that's something you want to agree to, or how you want to respond to that offer to the state of Ohio. And you and your lawyer will discuss that. Right now, your next hearing date is a trial scheduled for November 4th at 8:30 in the morning. When you're released on an own cognizance bond, which you are, and that will be continued, so I'm not changing that. You have to appear at all future court dates. Your next court date, as I said, is November 4th at 8:30. That's a trial. If this case is going to resolve in a plea, where you through your attorney work something out with the state of Ohio, it will not be on November 4th. It will be before that. We need to know, and your lawyer knows this, but we need to know, meaning the bailiff, this court, 2 weeks before November 4th. So in this case, that is October 21st. So about a month from now, we will need to be advised whether you're going to accept the state's offer, whether you've worked out some type of deal with them and you're going to enter a plea, or whether you want to go to trial. If it's going to be a plea, it'll be set then prior to the trial date. All right, so you're not going to come here on the trial date and plead guilty. If you're going to plead guilty, it's going to be before that. Understand that? And that happens, now obviously that will be your next hearing date, which I don't know at this point because you haven't decided that yet. But if you determine that you're going to plead guilty, know that it's going to be before November 4th, so you need to find out when that hearing date is. Your lawyer will tell you that, and he'll provide you notice of that, but if for whatever reason you don't get that, you need to reach out to him. You can reach out to the court if you want, but the obligation ultimately is yours to find out when your next hearing date is. So I want to make sure you understand that if it's going to be a plea, it will be before November 4th. You understand that? Mm-hmm. And you'll be required to be there for that. And obviously, if you're not, then your bond would be revoked, and that would be a separate felony you could be prosecuted for failing to appear at a court hearing when you're released on an owner cognizance bond. You understand that? You need to answer yes or no here.
Yes.
You have questions about it?
No.
Okay, you seem questioning that a little bit. I want to make sure you understand that. You understand
Yes.
it?
Yes.
Okay. All right, Mr. Shapiro, anything else for the record?
No, Your Honor, thank you.
Mr. Matthews?
No, Your Honor.
Do you have
Thank
any
you.
questions?
No, thank you.
Yep, okay. All right, thank you.
All rise. Your Honor, if it please the court, we're before the court this morning in the matter of the State of Ohio versus Robin J. Kidd, case number 25-CR-893. The defendant is present in the courtroom with her attorney, Mr. Chad Mulkey. We're before the court for purposes of a plea in line with a plea agreement that's been made between the parties, and if it please the court, put the terms of that agreement on the record at this time.
Please.
Pursuant to the agreement, Your Honor, the defendant is expected will plead guilty to count 1. That's an F3 OVI charge, as well as guilty to the specification attached to count 1. That's the OVI specification. This is a spec. It's not a 5 and 20 spec, Your Honor. This is the specification that in the past you pled to a 5 and 20 spec. It's under the new law that now if you have a prior conviction for the 5 and 20 spec, you can be found guilty of that now. So that's what that specification is. Upon the condition of those guilty pleas being forthcoming, at the time of sentencing, after findings of guilt, the state would dismiss count 2 and count 3 of the indictment. There is no agreement as to sentencing. My understanding is there will be a request for a pre-sentence report and drug and alcohol evaluation. The state would review those documents prior to making its sentencing recommendation, but it is mandatory prison on that spec, Your Honor.
What's mandatory prison on the offense itself?
I don't believe that it is, looking at the statute. I can refer the court to the statute that I'm talking about.
Unless that's changed also. If a prior felony, OVI, the F3 it's mandatory for at least 60 days, I think.
Well, that's if you don't plead to a spec, Judge, is my reading of the statute. And I would like to refer to the court to the statute, because God knows we want to get it right. And I looked at this.
It's always been mandatory prison on an F3 felony, OVI. That's out.
If I can ask you to take a look at it.
Well, go on, get the book right in front of me.
It's 451119, and it's G1E.
G1 what?
G1 and then lowercase e.
G1, B, C,
And then E. And then it's that first paragraph after that, it's the lowercase.
hang on, E.
Sure.
E, all right, then which
And then
I?
See that that Roman?
First one?
Yeah, 1.
Small I.
Small I.
All right. All right, give me a second.
Sure.
I just read it. It says mandatory prison term. Read.
Well, it's just mandatory prison term of 1, 2, 3, 4, or 5 years as required by and in accordance with G2.
Hey, wait. Okay.
And then it says,
If-
or.
If the offender
Right.
is convicted or pleads guilty to a specification of the type described in 2940-1413.
Right. And then it says, or mandatory term of 60 days if you don't plead to that spec.
Yeah?
So in this case, we're pleading to the spec. So the mandatory portion would be the 1, 2, 3, 4, or 5 years.
I disagree. It's the specification. So you're saying if she doesn't plead to the spec, then it's mandatory?
For 60 days.
I don't.
And that,
think
the
I
reason
agree.
I'm saying that, Judge, is it goes on to
What
say
does the specification require?
1, 2, 3, 4, or 5.
So that's what that. I don't agree with that reading.
Okay. Well, certainly it's, we would, the paperwork, Your Honor, we would want to change if to say that there's one word we would have to change in here about that then, because the paperwork has.
So your position is, if they plead to a specification, then obviously there's an additional prison term that has to be imposed for the specification. That's a mandatory 1, 2, 3, 4, 5 years. But then the underlying OVI becomes probationable?
It says the court may impose a prison term in addition to the mandatory prison term, is the next line. And the mandatory prison.
Hang on. Yeah, what that means is that I can get, in addition to the 60 days is mandatory. In addition to the 60 days, I could give her whatever you can get for F3, 9, 12, 18, 24, 30, 36. Just like the F4. If I send them, I can send them to prison on that, and say it's got to be for at least 60 consecutive days. Then I can give additional time if I want, of either 6, 7, 8, 9, 10, 11, 12, 13, 14, whatever. The May just says I can give them additional time on top of the 60 consecutive days.
Well, the reason I am bringing this up to the court and taking that position is my reading of it is that first sentence is, if you plead to a spec, you're getting a mandatory 1 to 5 years.
That's on the specification. That's for the specification. It has nothing to do with the underlying offense.
I understand, Your Honor. The reason why I am bringing it up is because I think that when it says the court may impose a prison term in addition to the mandatory prison term, I think it is referring to the spec on that.
No.
But
no way.
If I'm wrong,
That's been for 20 years I've been sitting up here.
okay. Then, Your Honor,
Felony 3 OVIs are always mandatory prison. They've always have been. That hasn't changed.
Okay. Forgive me for
60 days. It's not necessarily mandatory for. But 60 days is at least 60 consecutive days has to be mandatory. Then I may give an additional prison term.
Well, I'm sorry that I wasted the court's
I
time.
didn't waste my time.
And we'll have to look at page 2 of the paperwork here then, Your Honor, because and we'll have to add that the court must impose a mandatory prison term of at least 60 days, because I don't have that in here.
Okay, one second.
What they're talking about is there has to be at least 60 days on the OVI charge, minimum, in addition to the 1 to 5 years.
In addition to.
Yes, yeah, instead of 0 to 5 years of additional time, it's 60 days, 5 years of additional.
Read 29-29-13 G2. Page 360, if you've got the
I do.
2025-1 version. Very top left, very first paragraph.
What was that, Judge? 2?
G2.
If the third degree OVI. Or
Well, you're going to read the same way, aren't you?
yes, Judge. It's the same language.
Judge, we would move to have the prosecutor sit at defense table.
Well, I'm just trying to get it right, because, you
It says
know,
notwithstanding A through E, the offender is being sentenced for a 4th-degree felony offense or a 3rd-degree felony OVI offense. The court shall impose upon the offender a mandatory term of local incarceration or a mandatory prison term in accordance with the following. G1 deals with F4s. G2 deals with F3s. F3s are mandatory prison.
okay. Thank you for, forgive me for reading it wrong, Judge. And, we'll have to add to page 2 that mandatory 60 days. So, because I did not include that in this paperwork.
Where do you get the 12, 18, 24, 30?
That's 29, 29, 14, A3A.
All right, so paragraph 1, I wrote a mandatory prison term of 1, 2, 3, 4, 5 years in the specification, and the court shall impose an additional prison term of 60 consecutive days and may impose an additional prison term of 12, 18, 24. So, Mr. Schmoke, if you can review that with her.
Yes, Your Honor, thank you.
Thank you, sorry
No,
about that, Judge.
maybe you're right. I don't know. I've never done it that way. I mean, I can see why you're reading it the way you're reading it.
It doesn't change too much for us, okay? It just says, in addition to the 1, 2, 3, or 5 years that we talked about, it's an additional 60 days. So it could be like 1 year and 60 days, all right? And then after that, if the judge wanted to,
I'm wrong, but
he could
that's how I've always done
impose
it, isn't it?
12, 18, 24, 36, 42, or 60 months. So, all right, do you understand that?
That's mandatory.
Ye-
60 days.
Yes, correct, in addition to 1 year. So it's 1 year and 60 days at least, and we're free to argue that it should just stay at that. You may give you more time based on the precinct report and what we argue in court, or you may keep it at that, okay? That's the change, that's what we were talking about there. Are you still ready and okay to proceed today with your
Yes.
guilty plea to the OVI charge and the specification? All right. Your Honor, I've had enough time to consult with my client. I believe she's fully aware and understanding what we're doing here today with regard to the changes.
She's putting it's count 1, right? So count 2 would be the enhanced one, which we're dismissing that one, right?
Yes.
Okay.
Count 1 is the A1A.
Count 2 would be 120 days, which he's not doing that, so it's not, right. We're
Right,
good.
right.
Can't initial that.
Oh, ooh, yeah.
I know what you mean. You're talking about 451119G1E Roman numeral small 2.
I don't know, I'm just talking if it's over 0.17, then the minimum is 140 consecutive days.
Thank you.
Yeah, no.
And you're
we're not-
dismissing that count.
We're doing the A1A.
Absolutely.
Yeah, that's correct, Your Honor. We
Yeah.
are dismissing that count.
There you go, Steve.
No. All right.
Thank you, Judge.
All right, Mr. Mulkey, you heard Mr. DePiero's recitation of the plea discussions. Is that accurate?
Yes, Your Honor, I've heard that recitation conference with my client multiple occasions, Your Honor. I believe that she is competent and ready to go forward with the anticipated change of plea today as discussed previously. Thank you.
Thank you. Ms. Kidd, were you able to hear what everybody had to say?
Yes.
I know there's some clarification in terms of the sentence, but basically what was related in terms of the plea discussions, that you're going to plead guilty to count 1 with the specification. The remaining counts would get dismissed. We would defer sentencing to a future day to get some evaluations completed. Come back on a future day for sentencing, where each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine these issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, right?
Okay.
And you're dismissing the flee and eluding charge?
Yes, we are, Your Honor. The defendant was slow to stop.
Sorry?
Yes, we are.
Okay. All right, well, let's get started then. Ms. Kidd, how old are you?
65.
65? Okay. Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
It's prescribed.
Well, that was going to be my next question.
Yeah.
Usually people say no, and I say, what
It-
about prescribed? And they say yes. So you were anticipating my next question. So you've had some prescribed medication in the last couple of days?
Yes.
What's that?
Visceral and,
V with a V?
yeah,
Vistral, okay.
and then Prozac.
Okay. And you've had that tonight, this morning, or last night, probably?
Yes.
Do either of those medications affect your ability to understand or appreciate where you are, what's going on around you, or anything like that?
No.
So that neither of them are negatively impacting you right now, which makes it difficult for you to appreciate your surroundings?
No.
Okay. 1 second. All right, now you should have received, I know you did a copy of the indictment in this case. You should have got it sometime probably around, the middle of July. It's the document that sets forth the charges. Do you remember getting that?
Yes,
At some point, you would have had a chance to look that over. Is
yes,
that correct? You're pleading guilty to count one. There's a total of 3 counts. You're pleading guilty to 1 of counts. Count 1, what's alleged here, and what you'll be admitting to is on or about June 17th, 2025 in Paynesville, Lake County, Ohio, that you did operate a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It's further alleged that you previously were convicted of or pled guilty to a prior OVI under circumstances in which that conviction was a felony, specifically here in Lake County Common Pleas Court back on May 24th, 2010. That conduct constitutes the offense of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in this count?
yes.
Any questions about it?
No,
Now the specification here that you're also pleading guilty to alleges that you previously have been convicted or pled guilty to a specification of the type set forth in 2941.1413 of the revised code. And let me explain what that is to you, just so you know. I don't expect that you know what kind of specification is set forth in the statute. So let me advise you of that. It's the second one, correct? Mr.
Yes, Your Honor.
A2?
Yes, Your Honor.
What this specification alleges is that you previously have been convicted or pled guilty, well, that's what you just read, that within 20 years, to a specification which alleged that within 20 years you were convicted or pled guilty to 5 or more OVI offenses. So previously you were charged with an OVI that had a specification that alleged that you had been previously convicted of 5 or more OVI offenses within 20 years. So what this alleges that you previously pled guilty to that type of specification. You understand that?
yes,
Okay. Any questions about that?
no,
Now, there are 2 other counts of this indictment that are being dismissed pursuant to the agreement. Is that your understanding?
yes,
Any questions about either of those 2 charges?
no,
Well, now, before I can accept your guilty plea to the charge I just read to you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have a right to a trial. Now, a trial could be to me as a judge, where I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also do have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision. What that means is all 12 jurors would have to agree together, one way or the other, as to the charge and to the specification, whether you're guilty or not guilty. Do you understand that?
yes,
Do you understand by pleading guilty you're giving up your right to have a jury trial?
yes,
Now, if we had a trial, prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it is his job, or he bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence it stays with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
yes,
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. What it means, it's the amount of the evidence and the quality of that evidence the state has presented at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty at a trial of the charge. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes.
Now, in order to do that, or at least try to do that if we had a trial, the prosecutor would be bringing witnesses to come into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions, and that's called cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify at your own trial if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
So since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if we went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you give up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, this particular offense requires that a mandatory prison term of at least 60 days be imposed, and then if I determined that more time was required for the underlying offense, I could impose an additional term of either 12, 18, 24, 30, 36, 42, 48, 54, or 60 months be imposed. You understand that?
Yes.
Now, in regards to that, only the first 60 days are mandatory. If there's an additional prison term, it would be a non-mandatory prison term. You understand that?
Yes.
And the significance of that is it makes you eligible for certain programs, and it makes you eligible to request judicial release while you're serving a non-mandatory prison term.
Okay.
Now, in addition to that prison term I've just explained, in regards to the specification, the court will be required to impose a mandatory prison term of 1, 2, 3, 4, 5 years, which must be served prior to and consecutive to whatever other prison term the court imposes for the underlying offense itself. Do you understand that?
Yes.
So in this case, a minimum prison term of 14 months was required to be imposed. 1 year for the specification, 60 days for the underlying OVI, but you could be sentenced up to an overall total of 10 years in prison. You understand that? 5 years for the specification and 5 years for the OVI. Do you understand
Yes.
that? Now, whatever prison term is imposed for the specification is a mandatory prison term. It's the additional prison term after the 60 days that is non-mandatory. You understand that?
Yes.
And again, it may not mean much, but I think I explain a little bit why it's important is because when you're serving a mandatory prison term, you're not eligible for certain programs. You're not eligible to request judicial release. When you're serving a non-mandatory prison term, you'll become eligible to do certain programs in prison, to earn certain credit, and to request judicial release from the trial judge. And I'm not getting the specifics, but that's the basic difference between those two, is what the benefit is of having it be non-mandatory. Any questions about that?
No.
So you understand the range that you're facing here?
Yes.
Now, are you currently on probation or parole or any type of supervision to any other courts or agencies?
I don't think so. I was on probation.
When this happened?
Yeah, but it was like my last day.
Has that been
I don't know if he
terminated?
just took, yeah, I don't know if he terminated
Well,
it.
I'll tell you why I'm asking, just so you're advised of that. If you're on probation when you commit a new offense, there can be consequences with that court for committing a new crime while on probation. Now, it's nothing I have anything to do with, and nothing I'm not going to impose any. I can't impose any additional penalties, but they could violate your probation, determine that you're a probation violator because you committed a new offense while on probation, and be brought back before that judge and face additional consequences. Whether that's going to happen, if it's been terminated, then it won't happen. If not, it could happen, but I need to make sure you understand that.
Yes.
Okay. Do you have any other charges pending against you right now? Pending charges?
No.
Okay. If a prison sentence will be imposed, if you're released from prison after completing the entirety of the sentence, you could be placed on post-release control, sometimes referred to as parole. That's a period of supervision you would be on after you completed the prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes.
And if you are on post-release control at any point, never violate any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term is imposed by this court. Do you understand that?
Yes.
Now, in addition to the prison terms I just explained to you, there's other sanctions the court can impose and some I'm required to impose. There is a mandatory fine that I'm required to impose of at least $1,540, but I could fine you up to $10,500. Do you understand that?
Yep.
I'm also required to suspend your driver's license for at least 3 years, and I could suspend it permanently for the rest of your life. Do you understand that?
Yes.
I'm also required to forfeit any title or interest or ownership interest you have in the motor vehicle that is being operated at the time of the offense. Do you understand that?
Yes.
I could also order that you pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes. Is
Go
it
ahead.
mandatory to forfeit your car?
Yeah. If you own it, I mean, if you were driving someone else's car and you don't have any ownership interest in it, it wouldn't be. But if it's you own the car, then I have no discretion there. That's for any felony OVI, even the first-time felony OVI. May even be for a misdemeanor with 3 convictions. I don't know. So yeah. Now, a few moments ago, I explained the prison term you face. I explained how it's a mandatory prison term. That means at the time of sentencing, I cannot place you on community control sanctions or probation immediately. You'll have to serve this mandatory prison sentence first. You understand that?
Yes.
Now, the law does allow me to place you on community control sanctions after you've served whatever prison sentence that I've imposed. Now, I don't have to do that. I'm not required to do that. But you are eligible for that. You understand that?
Yes.
You also, as I alluded upon before, would be eligible to request the court place you on judicial release. Judicial release is a motion or a request you would make of the trial judge, which would be me if I'm still sitting here at that time, or whoever takes my place if I'm not sitting here at that time, where you ask them to be released from prison early before you've completed the entire prison sentence and put on probation at that point. Now, you are eligible for that, but you're only eligible for that after you've served whatever mandatory prison sentence was ordered. And if there's some non-mandatory prison sentence, that additional prison term that I've explained that was ordered, you'd be eligible to request judicial release at that point. Do you understand that?
Yes.
Just because you're eligible doesn't mean it's automatic, but it means the court would consider that and then issue a ruling on that. Do you understand that?
Yes.
Okay. Lastly, when we do proceed to the sentencing hearing, you'll have a right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to follow that if I don't think that's the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions for me about the potential penalties you face by pleading guilty?
No.
Understand all the possible consequences? You
Yes.
still want to plead guilty?
Yes.
Have you had enough time to discuss this case with your attorney and have him go over everything with you and answer your questions?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering this guilty plea freely and voluntarily?
Yes.
All right. You have any questions for me at this time, Ms. Kidd, regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No.
Do you need any more time to speak with your lawyer before we go forward with your plea?
I was hoping to get a bond.
She'd like to address bond, Your Honor, when appropriate.
That would be at the conclusion of this. We can
Thank you, Your Honor.
discuss that. Any questions or anything else you want to talk about with your lawyer at this point?
No.
All right, then what's going to happen at this point, the prosecutor is going to set forth for me what he believes the facts would show if we had a trial. I want you to listen to him because then I got some questions for you, all right?
Okay.
Mr. DePiero.
Thank you, Your Honor. Your Honor, the facts would show June 17, 2025, in the city of Painesville, Lake County, Ohio, the defendant, Robin Kidd, was driving a 2012 Honda Civic on Richmond Street at Prospect. The Painesville police officer, who was on duty in a uniform and a marked police car, observed the defendant to be driving her car at a high rate of speed, used the radar device, clocked her going 47 in a 25-mile-an-hour zone. The officer then turned around to follow and stop the vehicle. The defendant kept going on Richmond Street and towards Jackson, and at a high rate of speed. The officer observed the defendant almost strike the curb and then take a fast right onto Jackson Street from Richmond Street. The officer observed the defendant then to drive in the wrong lane, so in the lane of opposing travel for about 500 feet while on Jackson Street. Also observed the defendant to be drifting her vehicle towards the curb, striking the curb, driving partially on the curb and almost missing a telephone pole. Eventually she stopped. The officer had activated his lights and sirens just before the turn onto Jackson. So she stopped at about Jefferson Street. She had a strong odor of alcoholic beverage about her breath, bloodshot, glassy eyes, slurred speech. She could barely walk on her own. Couldn't even do sobriety tests because of that. She nearly fell on the sidewalk. She was offered a breath test that she agreed to take, and the breathalyzer was a .218 grams per 210 liter, Your Honor. This happened in the city of Painesville, Lake County, Ohio. And as for the defendant did plead guilty and was convicted, actually was sentenced on May 24, 2010 in case number 09CR609 in this Court of Common Pleas, Lake County, before the Honorable Judge Lucci to a felony of the 4th degree OVI in violation of Revised Code 4511-19A1A. And in that same case, at that same time, she was also convicted of a specification pursuant to Revised Code Section 2941.1413 of the 5 and 20 spec.
Thank you.
Thank you.
Ms. Kidd, were you able to hear what the prosecutor had to say regarding what he believes the facts would show if we had a trial?
I'm sorry.
Were you able to hear what he just had to say?
Yes.
What, if anything, did he say about those facts as he presented them? Are they true? Did you do what he said?
Yes.
Did you operate a motor vehicle under the influence of alcohol on that night?
Yes.
Very well then, regarding count 1, charging with operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a felony of the 3rd degree with the specification that you previously have been convicted of a 5 convictions in 20-year period of time specification. What is your plea to that?
The 5 convictions and...
So you previously pled guilty, not today, but you previously, when you pled guilty to an OVI, there was a specification that said you had 5 prior convictions in 20 years, which you previously pled guilty to that. That's not what you're being charged with today. You're not being charged with having 5 in 20 years. You're being charged with having previously pled guilty to a specification in the past.
Yes.
So what is your plea to the underlying OVI offense?
Guilty.
And what is your plea to that specification?
Guilty.
I have in my possession here a document called a written plea of guilty and judgment entry, which explains everything I've just talked about with you. Before I could accept your plea, I need to make sure you understand the document and that you sign it here in open court. My understanding is before I came out here, you had a chance to review this document with your lawyer. Is that correct?
Yes.
Mr. Mulkey, is that accurate? Did you read this over with Ms. Kidd, review it with her, answer her questions?
Yes, Your Honor.
Did she indicate an understanding of the document to you?
She did.
Is that correct, Ms. Kidd?
Yes.
It also appears you signed the document. Did you sign it?
Yes.
Yeah, it appears you did. All right. Mr. Mulkey, did you witness that?
I witnessed it.
Mr. DePiero?
Yes, Your Honor, I did.
Very well then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. Felony of the 3rd degree in violation of 4511.19A1A, as well as specification pursuant to 2941.1413. The remaining counts of the indictment will be dismissed at sentencing. Sentencing will be deferred. However, I'm going to order a pre-sentence report investigation, drug and alcohol evaluation. Now, you wanted to be heard on the matter of bond, Mr. Mulkey?
Please, Your Honor.
Go ahead.
Thank you, Your Honor. Your Honor, my client, understanding that she is facing mandatory prison time, would like some time out on bond to get some affairs in order. Specifically, Your Honor, she had a condo at an address of 1651 Minner Avenue. She would like to resolve any outstanding financial obligations with respect to that condo by way of utilities and any other bills that she has. Furthermore, she has a daughter that she'd like...
A what?
A daughter.
Oh, okay.
Yeah, right. That she'd like to visit with outside the confines of the Lake County Jail. From my understanding, I believe has just returned from China recently. Your Honor, she does have reliable transportation to and from court. She indicated she could take an Uber and also obtain transportation.
Let me interrupt you for 1 minute. What's the state's position? Why is there no bond in this case?
Well, I was just looking
Yeah,
for an answer to that, Your Honor. I see the
I
municipal.
saw it in municipal court that they had a hearing and made that finding, but
Right.
it's pretty rare.
This is the defendant's 9th prior OVI in her life. Well, actually, I have a note here, 9 prior OVIs in her lifetime, prior to this, I believe. The last being the felony.
I get she's got a lot, but we've seen this before.
Sure. No, I understand, Your Honor. I don't have, I don't know what the hearing was.
I mean, I know you weren't a part of it. It was the
Yeah.
municipal court, so it was the municipal judge and municipal prosecutor.
I mean, this.
It's unusual.
I gave a summary of the facts, but this was, she was traveling in the wrong lane, and the police report does note that when she was traveling in the wrong lane, there were cars in the other lane that had to kind of move over. So maybe that's what the Muni Court judge was considering, Judge. I don't know.
Mr. Mulkey, what bond are you requesting?
Your Honor, at this time, she would be requesting a recognizance bond. The reason for that, she's indigent. She cannot afford to post any sort of a cash bond at this time, Your Honor. Furthermore, the court did hear the recitation of the facts prior to accepting her guilty plea. Understandably, the nature of the offense itself is always going to be concerning when it's this level of a felony. I would ask the court, at least for bond purposes, not to consider any extraordinary circumstances beyond the seriousness of similar offenses of this type, Your Honor.
I'm going to set bond $5,000, cash surety 10%, but there's going to be a condition that she's on scram monitoring. And she's going to have to get that hooked up before she's released.
Well, that concludes my argument,
So
Your Honor.
what that means, Ms. Kidd, is that you're going to have a scram monitor on. You're going to have to pay for that, but it's going to monitor any alcohol intake. And if there's any at all, your bond will be immediately revoked and a warrant will be issued. Do you understand that?
Yes.
Now, I've ordered these reports. Probation's going to meet with you. It's important you're open and honest with them because they're going to check and verify everything you tell them. If you violate any of the conditions of your bond, another condition is no driving. No driving at all. If you violate any of the conditions, again, your bond will be revoked immediately. A warrant will be issued for your arrest, and that will be taken into account then when determining what the appropriate sentence is. Here, I will take that into consideration. If you fail to show up to the probation department for your interviews, so that's what I want to say. You're going to have to appear at the probation department. If you don't meet with them before you're released from jail, you need to immediately contact them. All right, your attorney will tell you how to do that. But you need to immediately contact the probation department if you're released without having talked to them.
Okay.
I don't know exactly when you're going to get released because the equipment's got to get hooked up. If you meet with them before that, then they'll have given you a date to come back and see them. If you haven't, then you need to contact them immediately. You understand that?
Yes.
If you don't do that, again, then your bond will get revoked. You understand that? All right. Anything else, Mr. Chairman?
No, Your Honor, thank you.
All right.
No, Your
thank you.
Honor, thank you.
All rise.